meeting for the proposed Cairn Duhie wind farm, our reference WIN-270-16. Could I ask everybody to leave their videos on but mute your microphones just for this introductory part of the proceedings? If you cannot hear or see me, please indicate now. And I'm not seeing any indication that people can't, so I'm assuming you all can. I am in a conference room in the DPA offices in Falkirk, and I'm using a hands-free remote microphone. Can everybody hear me clearly? Excellent, thank you. Welcome to the pre-inquiry meeting in relation to the application by Renewable Energy Systems Limited for consent for the construction and operation of a 16-turbine wind farm and associated infrastructure and access tracks sited approximately 15 kilometres to the southeast of Nairn and within the Highland Council area. I will refer to it as Cairn Duhie Wind Farm throughout the proceedings. My name is Sinead Lynch and I am a reporter with the Scottish Government's Planning and Environmental Appeals Division. I've been appointed jointly with Karen Haywood, Assistant Chief Reporter, to hold the inquiry and report to Scottish ministers on this application, which has been submitted under Section 36 of the 1989 Electricity Act. In Section 36 cases, it is the minister who will decide whether or not to approve the application after consideration of our report. You should know Ms. Haywood can't be with us today for personal reasons, and so Mr. David Little, who is also an Assistant Chief Reporter, is sitting in her stead. He will not be involved in any of the decision-making process moving forward and is here today to assist with any procedural matters should they arise that require discussion and deliberation. Some very brief housekeeping matters before we move on to the main items on the agenda. You will all be aware that this meeting is being broadcast live and is also being recorded. Callum, whom you all saw earlier and can see on your screens, will remain online throughout the course of this meeting to ensure that there are no technical difficulties, or if there are, he can resolve them hopefully as fast as possible. By taking part in this virtual meeting, you are consenting to being filmed, and you're also consenting to the use and storage of the images and sound recordings. Those images may be used for webcasting and training purposes, but they are also used for the keeping of historical records, and those records are made available to the public. I know we've all got very used to undertaking these virtual processes, which is useful, but you may find it useful to use the grid view available on this platform. And please remember to mute your microphone when speaking. I understand it's very easy to forget to do so, so I may have to remind you. If you want to attract my attention, could you please wave or speak by switching your microphone back on? And if we could all remember that, although it is a virtual meeting, could all mobile devices be switched off or at least switched to silent for the duration of the meeting? We here in DPA are adhering to government current COVID-19 restrictions and guidance, and we also would hope that you are adhering to those applicable COVID-19 regulations and guidance at your location, particularly if you are in a place of work or attending this meeting with your colleagues. I haven't planned any formal breaks in the meeting this morning. I am anticipating that we will rattle through it, I hope, and finish in a timely fashion. I will review this in an hour or so to see if parties would appreciate a short break for any reason. I would remind everybody that this meeting concerns only the arrangements for any inquiry and any other procedures necessary to enable Ms. Haywood and I to consider this case. It does not therefore form part of the inquiry itself, and no evidence on the merits or otherwise of the proposal will be heard today. We circulated the agenda for the meeting in August, and you have had the opportunity to consider our current thinking on the procedures. So we would hope to progress quickly through the items on the agenda, and we intend only to debate any areas of disagreement and note any areas of agreement. Turning to item 2 on the agenda, could I ask the participants in each team to introduce themselves and their colleagues, identifying what part those colleagues will play in the proceedings moving forward. Could we start with the applicant, please?
Thank you, ma'am. Good morning. My name is Marcus Trinick. I'm a solicitor of Queen's Counsel, and I'm instructed by Lizzie Tainch, who sits to my left, of Wright Johnson Mackenzie. And to her left is Paula Batchelor, who is the applicant's project manager for Scotland. On screen, you will see Craig Smith, who is project manager for Cairn Duhie. Also in the room, but I think probably out of your eye shot, is Amy McDougall of Wright Johnson Mackenzie. And observing on the screen is David Bell of David Bell Planning, who will be dealing with planning evidence. I apologise, ma'am, that we seem so distant. We have tried to zoom the image as far as we can without breaking the system.
That's absolutely fine. I can see you and hear you clearly, so absolutely not a problem. Right, thank you very much. And are those all your anticipated party members, Mr. Trinick?
No, ma'am. And in terms of witnesses, they're the missing people here today.
Okay.
Sam Oxley of Land Use Consultants will be giving evidence on landscape and visual matters. In fact, the other one is present, and that's David Bell. He'll be dealing with planning. We don't anticipate the need to call anybody else at present.
Okay. Right. Thank you very much, Mr. Trinick. If we could move to the council and introductions for your party, please.
Yes, good morning, ma'am. My name is James Finley, Queen's Counsel at the Scottish and English Bars. I'm instructed by Cairn Lyons, who appears on screen, and Simon Heinsohn is here today. Simon will be dealing with the policy evidence, and we're anticipating Carol Anderson, who's not here today, will be dealing with the landscape and visual.
And could I ask Rhoda Banfro, who's not here today but is indicated on your list, what part will Ms. Banfro be playing?
I'll pass that to Cairn Lyons, but I have a feeling she was just going to be observing for experience, unless if there's anything to add to that, I'm sure Cairn will add.
That's quite correct. She is a colleague of mine within the legal team. Thank you.
Lovely. Thank you very much. There may be observers on the webcast. I don't actually see anybody in my grid view. So my question about any other people participating or intending to participate today is slightly redundant, I think. Thank you all for the introductions. That is very useful. Are there any preliminary questions at this stage before we move on to item 3? No? Thank you. Item 3 looks at the Code of Practice for handling inquiries under the Electricity Act 1989. You will recall that I sent a hyperlink in the agenda to you all. So for those of you who are not familiar with the Code of Practice, the DPEA Code of Practice is modelled on the 2013 Planning Appeals Regulations, and we expect to apply that Code of Practice to this case. Essentially, it is a flexible code which allows for a choice of procedures. Each issue will be dealt with by the most appropriate mode of examination, be that inquiry, hearing, or written submissions. On some issues, we may find that sufficient information has already been submitted and no further procedure will be required. When the report is submitted to Scottish ministers, all of the environmental information submitted by the applicant, together with all the consultation responses, any representations, will all be taken into account. The type of procedure being followed, or the absence of any further procedure other than the information already submitted is not an indication of the importance of a particular issue. For those of you who haven't been involved in a procedure relating to an application for under Section 36 of the Electricity Act, I don't think there's anybody here who falls readily into that category, but very briefly, the hearing and inquiry sessions, the difference between them is a hearing session is a structured discussion led by the reporters and will be suitable for topics where there are differences of opinions on less technical issues. Inquiry sessions will be chaired by reporters, but each party will present evidence and will be subject to cross-examination by those of opposing views. Parties will generally be legally represented, and their legal representation will undertake that cross-examination or questioning. Ms. Haywood and I will no doubt have questions, and the inquiry session is a more formal process and is particularly suited to topics where the evidence is technical in nature. You will have seen in the agenda and the appendices attached to it that we have already set out how we think the case should proceed, and you have both parties responded indicating how you think the case should proceed, and we can discuss these thoughts in more detail as we go through the agenda. Site visits will be a critical part of our evidence gathering, and Ms. Haywood and I intend to carry out unaccompanied site inspections during the first week in October, subject to weather. And those site inspections will include the site itself, landscape character units and viewpoints identified in the landscape and visual impact assessments of all the parties. Does anybody have any questions on the code of practice and or the options it offers at this stage? No? We can then move on to item 4 of the agenda, which is any additional information and the potential impact on the draft timetable. Really, we are looking here to ensure that we and all the parties to this process have any updates to the application since it was made. I note that the applicant has indicated that an updated cumulative landscape and visual impact assessment would be submitted. That would be useful, and we would expect that to take into account any new wind farm proposals at the various stages in the process. Could the applicant confirm that progress has been made on that updated cumulative impact assessment? And if progress has been made, when we might expect to have that submitted?
Thank you, ma'am. Yes, progress has been made. A cut-off date has been agreed with the Highland Council. We will be sending the council today a map with what we believe is the updated baseline, cumulative baseline, seeking their agreement. That will lead to formal updating of the landscape and visual impact assessment, which will be published by the 14th of October, maybe sooner, but by the 14th of October. And I do request a direction from you that that information is required for the purposes of the inquiry. That will avoid advertisement, but the information will obviously come to others' attention. There is an additional piece of information, factual information, really. It might not even be statutory information. But I think it's fair to tell the council about this. The substation, which is proposed, is currently shown on EIA figure 4.1. That's just for the record. And it measures 150 by 100 meters, but the connection was to be at 275 kV direct to the line crossing the site. That has been amended. The connection will now be at 33 kV, involving an external grid connection. And the measurements of that substation, which will be sent out today to everybody, are 50 meters by 34. And because of the substantial difference, I think it's fair that the information should be published. and that will be published today and included within the statutory information sent to you on 14 October.
Okay. Right. Thank you for that. Certainly, we would be content to issue a direction so that can avoid the need for further advertising of the updated cumulative impact assessment. Can I just clarify, Mr. Trinick? You said the site plan alteration in relation to the substation would be published today, but sent with the updated cumulative impact on the 14th of October. Is that correct?
That's correct.
Okay, thank you. Does the council have any comment on that information from the applicant at this point?
No, that's all either agreed or seems sensible.
Okay. Thank you, Mr. Findlay. Obviously, Ms. Haywood and I will require hard copies of that information. Would the council require additional hard copies?
I'd have thought one hard copy should be sufficient.
Thank you. In terms of timescales, the parties will be aware that the original draft timetable has moved back from the end of January 2023 to December 2022 for the holding of any required oral process. If we proceed with an inquiry or hearing on these matters, we would not see separate submissions on these additional work. So we are quite content that responses to the updated cumulative impact assessment and the changes to the site layout could be addressed as part of your inquiry statements and recognitions. Are the parties content with that? Okay.
Thank you, ma'am. Yes.
Okay. We can discuss the timing of those in more detail when we get to that part of the agenda. We will also require an update on any changes to council or government policy since the planning statement, which I think was February 2021, and the council's report, which was February 2022. Again, this update could be provided in the statements that will be submitted for any policy-related hearing session so that those are as up-to-date as possible when we get to that point. Are there any other updates that are anticipated by any party at this point? No. Thank you. National Planning Framework 4. We are conscious that it may be adopted as we move through this process. The date of its ultimate adoption is not known, but should it be within the timeline of this process, we will make provision for any additional comments. Should that happen in time frame that would allow parties to address that in their statements, that would be the most sensible way to proceed. Are there any contrary views as to how we might manage MPF4 and any comments on it?
No, ma'am, but I think it's relevant to the preparation timetable, and we're going to come on to that.
Okay. Okay, moving to item 5, which is the provisional assessment of the main issues to be addressed, those requiring further procedure and participation in any further procedure that is deemed to be required. The items listed in Appendix 1 of the agenda have not changed since it was issued, and where we have indicated that further information will not be required, we remain of that view. Are there any comments on the issues we have identified in Appendix 1?
May I go first, ma'am?
Indeed.
So far as planning and energy policy is concerned, we do believe that a hearing session will be appropriate. Current information seems to be that MPF4 will come out in late September or October, although who knows. But there's also the refresh, I think it's called, of the onshore wind policy statement, which may come out in the same general time frame. And depending on what happens with the UK government, be a new energy strategy to be considered at the inquiry as well. Now, for these reasons, I think there's a very good reason for having a hearing session rather than simply written submissions. There's a lot of new material to discuss. That's the only comment I've got on what the views that you and Ms. Hayward have given in Appendix 1. I think that the council might demur from having an inquiry session for landscape and visual. I strongly maintain that that is required. It's a technical issue on which I think you will benefit and receive better information if there is a formal examination of the evidence. Otherwise, I've got no comments on Appendix 1.
Okay, thank you, Mr. Trinick. Mr. Findlay?
Well, ma'am, in terms of planning and energy policy, I see the force in what Mr. Trinick's saying, that there may not be an adopted version of MPF4, but there certainly may be another version of it. And there may be another version, perhaps even adopted, of the onshore wind policy statement. So obviously it'd be for you to set the agenda in due course, but there may be, I think there does seem to be justification for having a provision at this stage for a hearing session. In terms of landscape and visual, Highland Council's preference is for a hearing session, and we would like to think a successful hearing session at Drumholliston Wind Farm, but different reporters deal with matters in different ways. So as Mr. Trinick foreshadowed, our preference is for a hearing session, but I'm happy to leave that to you and Ms. Hayward. In terms of conditions, it definitely is sensible to make provision for a conditions hearing session, but the parties are well known to one another, and it is highly likely that the issues in dispute will be resolved completely or reduced to one or two matters. But no doubt that will become apparent during the course of the run up to the inquiry session or hearing session, as it may be.
Thank you, Mr. Findlay. Mr. Trinick, can I just revert to you about conditions? I note you didn't mention them, but I note in submissions to date that a hearing is the preferred route of progress.
Yes, ma'am. In other words, I agree with your Appendix 1. Yes, I think there needs to be a hearing session to discuss what is left of conditions which needs discussion.
Thank you. As we progress and as the time frame has compacted, I think is probably the best way to describe it. The same process in terms of submissions will need to be adhered to. You've already indicated to me which witnesses you expect to bring to any such sessions, be it inquiry or hearing. Could we talk in round terms about the amount of time that might be required at either or any of this of the sessions? If an inquiry session were to proceed for landscape and visual impact assessment matters, would a day be sufficient, either inquiry or hearing? Mr. Trinick?
The thing is, if there's an inquiry session, which I'd have asked for, I think that might take a day and a bit, a day and a half, to be pessimistic. I think the rest of the procedure could be adequately catered for towards the end of the second day. I think this is a 2-day inquiry in total, if we manage things properly.
Okay, Mr. Finlay?
Yes, I would hope that we'd finish landscape and visual in a day and a half. And we should be capable of dealing with policy and conditions. I think it'd be mainly policy in the remaining half day.
So in total, a 2-day procedure, be it inquiry or hearing, or a combination of both, or all topics. Okay. In terms of conditions and in response to Mr. Finlay's comments on the progress on conditions to date, is there, I note that the Council's initial report had a set of conditions attached to it. Is it likely that there could be a set of agreed conditions at any point soon? Has any progress been made on that to date?
We have prepared a set of conditions which will be ready for release to Highland Council before the end of this week.
Okay.
So I hope that kicks things off in the right direction.
Absolutely. Thank you. So, in summary, in relation to procedures for examining this application, all parties are in agreement that it would be a 2-day procedure, and that could encompass landscape and visual impact assessment, be that an inquiry or a hearing session, and then hearing sessions for policy and potentially conditions should any lack of agreement remain at that point in time. Okay, moving to item 6, the hearing of evidence, the procedure for any inquiry and hearing sessions, and a discussion on whether or not it is an in-person or a virtual process. I've already run through what will briefly happen at inquiry and hearing sessions and don't think I need to repeat that. I think the key question here is whether or not it is an in-person or virtual process. At DPA, we are moving back to in-person processes. Virtual process for pre-inquiry meetings are very useful and efficient. Could I have the party's thoughts on those two options? Mr. Trinick?
So, ma'am, mine is no doubt at all. In person is to be strongly preferred. I've done 5 or 6 virtual inquiries, maybe more, I can't remember. And having done one 2 weeks ago in Aberdeenshire in person, it reinforced my view that in-person inquiries are more efficient, they're better, they don't suffer from broadband breakdowns, they enable parties to meet and talk. In all ways, they are to be strongly preferred.
Okay, noted. And Mr. Finlay?
Highland Council take a broadly neutral view as to which is to be preferred. They see advantages in both.
Okay, my note of the meeting will indicate in which direction we intend going, but I would let you know that at the moment I am veering towards in-person for the inquiry and any hearing sessions over the 2 days. My thoughts on that will be set out in the note of the meeting and confirmation on that decision. Unless there's any other comment on that, I will move to item 7.
Sorry, ma'am, there is one comment.
Yes.
In anticipation that we might be going for an in-person inquiry, we have, because your item 5 also, item 6 also mentions Well, item 7 actually mentions this, so my apologies. I'm anticipating item 7, but we have investigated venues, and the Grant Arms in Granton, which was used for the last Duhie inquiry, is available for the dates you require, just so you know.
Right, that is useful to know. It's coming up in item 7. Having decided that a 2-day process would be sufficient, for various reasons, the 14th and 15th of December would be our preferred dates. How do they sit with the parties? Mr. Trenick? That would be the
We're
Wednesday.
content. Yes, we're content with the either 13th, 14th, or the 14th, 15th. I think I'm likely to be in Mr. Finley's hands there. We can do either.
Okay, thank you. Mr. Finley, did you?
Yes, our preference, reasonably strong preference for the 13th, 14th, but we can accommodate the 14th, 15th if necessary.
Okay. I will confirm that, and I will note your preference for the 13th and 14th, but noting that it is possible for you to do the 14th and 15th.
My only concern is that if for some reason we were to not finish in 2 days, that would cause problems if we started on the Wednesday, but it wouldn't cause problems if we started on the Tuesday.
Noted. Thank you both. I had intended discussing the venue, but Mr. Trinick has preempted me in terms of the hotel. So that is the Grant. So could you say the name of the hotel again, please, Mr. Trinick?
Yes, ma'am. I'm sorry to preempt you there. It is the Grant Arms, which is a large hotel in the middle of Granton. And it was used for the first Duhie inquiry. It's got a room that will sit 60 in an appropriate format for an inquiry or hearing session. And there are available breakout rooms. And as I said, we have checked the availability of the hotel, and it's available for the 13th, 14th, 15th of December.
Okay, thank you very much for that research. It is appreciated. Do the council have any strong thoughts on a venue or any thoughts on a venue? No.
No, just to say that Grant Arms seems fine.
Okay. Well, we will. Mr. Little?
Sorry.
That is it's causing some feedback. I apologize. We are using a standalone microphone in our contract. Mr. Little is just going to leave the meeting and rejoin, and hopefully that technical issue can be resolved. Shall I move on and come back to you, Mr. Little? Right. So if we're agreed that the dates will be in the parameters of the 13th to the 15th, and the Grant Arms would be the preferred venue as it's available and suitable, I will make a note of that in my notes of this meeting and circulate that. While Mr. Little is sorting the technical issue, I will move on to item 8, which is site inspections. As I indicated at the outset of the meeting, Ms. Haywood and I intend to carry out unaccompanied site visits over a number of days in the first week in October. And given that the sessions will be in mid-December, I would think it would be prudent to identify any viewpoints, parts of the site, any landscape features or landscape character units that any party considers might require an accompanied site inspection. Could they indicate that to us in the next week in writing, so that that can be organised. And I say that because of weather and daylight unpredictability in December in the area. I have not identified any of those features that would require an accompanied site visit myself, but should any party wish to accompany Ms Haywood and I to particular parts of either the site or the landscape character units or viewpoints, we are very happy to accommodate that at this stage in the proceedings. It will simply make for a more efficient process rather than having to wait until the weather is probably more clement. Could you each give thought to that and perhaps confirm if there are any accompanied site visits required, and if that could be done by the 16th of September? And you can notify Audrey Duhie, who is the case officer, and we can then make any appropriate arrangements that are required. If you don't require accompanied site visits, then it would be useful if you could just simply confirm that in writing to us. Thank you. Mr. Little, can I come back to you on item 7?
Yes, thank you. Sorry, the technical issue was me pressing. I shouldn't have done. It's just a small point. The grant arms, I heard, suitable for 60 at an inquiry and a hearing, and we'd used it before. And it may be that we still have COVID restrictions, which would mean 1 metre spacing. And just it sounds with the limited number of parties that room might still be big enough, even with needing a bit more space per person. I just wondered if either the council or the applicant thought on that point.
That's actually well noted, Mr. Little. Our DPA current COVID-19 regulations require us to be a metre apart and to wear face masks when circulating. The metre apart does impose slightly different space requirements in venues. If it's 60, it sounds like it may be possible, given the number of participants and witnesses we have identified. Obviously, provision will have to be made for members of the public and those wishing to observe or participate on the day. But we will investigate whether or not it is possible to adhere to our current guidelines and use that venue. If not, we will revert to you as soon as we possibly can. Moving to item 9, which is an item looking at the exchange of documents, written submissions, core documents, etc. We will issue, as Mr. Trinick mentioned earlier, directions and formal procedure notices requiring any written submissions and or additional information. All those will be issued in due course and on a timely basis. Looking at core documents, the applicant is asked to compile a core documents list that contains hyperlinks to documents that are already held by DPA, either as part of our core documents library or as part of the case file as provided by Energy Consents Unit. This will ensure that easy access to documents is available to participants, and it also allows the case officer to compile the core documents easily. When the note of this meeting is issued, the applicant will be sent a link to the relevant libraries and a list of the case file documents that are held with URLs. No other or separate copies of the documents already held by us needs to be provided. Any documents not already held by DPA should be submitted in the usual fashion. In line with Scottish Government policy, USBs will be provided to participants, one per participant, i.e. one for the applicant, one for the authority, and so on. These USBs will be encrypted. The encryption will consist of a password. That is the extent of the encryption, to allow you to access the information on the USB. You will be provided with information regarding the handling, storage, and ultimate destruction of the USB by our IT department here at DPEA. It sounds very Mission Impossible. And once precognitions have been received and processed, these USBs will be distributed to all the parties. The IT team here will liaise with the case officer to prepare and distribute those USBs. Are there any comments on that proposed process?
No, ma'am, at all. It sounds very sensible and to be expected. The draft core document list has already been prepared here and will be circulated shortly.
Lovely. Thank you, Mr. Trinick. Mr. Findlay, any?
No, that does seem sensible, but can I put a request that the USB has all the documents on it, not just hyperlinks? Because even though the reference to a core library, and that even though there may be good Wi-Fi connection at the Grant Arms, it's useful to have the actual documents there, because having to rely on hyperlinks tends to, in experience, slow matters down significantly.
Okay, I shall certainly
Agreed.
explore that. I'll confirm in the note of the meeting, if that's possible. I don't see why it wouldn't be possible to put the actual documents on the USB rather than the hyperlink. And I do note the difficulty that can arise using hyperlinks, particularly where there is poor or slow Wi-Fi. Mr. Trinick, I think you were.
No, just fully agree with Mr. Finlay.
Okay, good. Thank you very much. Well, the next part of this item is moving to key anticipated dates for the procedure to be followed to carry out the oral procedures in December. I will, of course, include all of these dates in my note of this meeting, but for discussion purposes today, I have set out some dates which I think, if we are to achieve the 13th, 14th or 15th of December, then it is key that these timelines are adhered to. They're entirely possible, just don't give a huge amount of time for slippage should something unforeseen happen. I intend to issue this note by the 13th of September, which is a week from now. We will commence any written submission processes in that week as well. I would like to see any statements of agreement, if there are any, by the 26th of September. That is approximately 3 weeks from now. And any draft conditions, which I think, Mr. Trinick, you said would be available by the 26th of September as well. You've also indicated, Mr. Trinick, that there is a draft core document list. I've put the 26th of September for submission of that. Should be achievable given the indications during our discussion this morning. Inquiry and hearing statements, the 24th of October. That is the Monday after half term, certainly in most parts of Scotland. If that is an issue, please let me know if you have annual leave booked and that is going to be problematic. I'm hoping it won't. And with those inquiry and hearing statements on the 24th of October, second draft of conditions, if it's required, should be submitted. A final document list and the distribution of core documents would also occur on the 24th of October. Recognitions could then be submitted on the 21st of November. And then looking at the inquiry and hearing sessions on the 13th, 14th and or 15th of December. We would then be looking at any written closing submissions if required, and we can discuss this further at the oral sessions, but for the purposes of our diaries, the council's written closing submission on the 23rd of December and the applicants on the 6th of January. Slightly longer than normal to take into account the holidays over Christmas and New Year. Now, I realise that that is a large number of dates in a short period of time, but I think based on our discussions, as I said, entirely achievable. Any issues with those dates that either party can envisage initially?
If I go first,
Yep.
We're fine with almost everything, but there's one date in particular, the 24th of October for hearing statements, and you said inquiry statements, but I interpret that to mean the what I call the inquiry report, the
Yes.
full evidence. Yeah, fine. For the inquiry report, assuming that's what we have and it's landscape and visual, that may be doable. But for the hearing statement for policy, I don't think it's desirable, because if NPF 4 does come out at mid-October, we do want time to be able to prepare a proper hearing statement, taking that into account, and possibly also the refresh of the onshore wind policy statement. And the date I had in mind, I just put for discussion and your decision, is the 15th of November for the policy hearing statement. As I say, the inquiry report, I think we can probably do 24 October. It's tight, but we can do it. The other comment I have is that it's kind of you, ma'am, thinking me doing my closing submissions over Christmas, but I would ask for 1 week more on the 13th of January, if that's possible.
It absolutely is possible. Yes, I had thought you might like to do written closing submissions between Christmas and New Year, but you know that the 13th of January is absolutely fine. Going back to policy hearing statement, I am quite happy to have separate dates for inquiry reports and hearing statements, and I do anticipate that there will be discussion in those hearing statements in relation to updated NPF 4 and updated onshore wind policy. You have suggested the 14th of November. Would it be more sensible to keep it to the 21st of November so they could be submitted with precognitions, or that won't work in terms of timing? The 14th is fine. I have no issue with that date as long as parties are content. That gives enough time. From my point of view, that is a month before any policy hearing, so certainly plenty of time for Ms. Haywood and I to digest the contents.
I would grab the opportunity of the 21st of November, but content with the 14th.
Okay. Mr. Finlay, any thoughts?
Yes, I do have concerns about the precognitions are coming, the date of the precognitions and the inquiry reports, because for two reasons. One is my witness has as holiday commitments and other commitments. And secondly, I know Mr. Trinick and I are engaged in another inquiry which begins at the beginning of November. We were looking for 4 weeks before the 13th for inquiry reports, which would be the 15th of November. But potentially 5 weeks would be, or even 6 weeks, but our preference would be 4 weeks before the inquiry date for the inquiry reports and 2 weeks for recognitions. If it's going to be an inquiry session, then in our submission that would leave ample time for preparation. I can understand that more time might be needed were it going to be a hearing session. If it is to be an inquiry session, it would certainly, we would much appreciate that 4 week and 2 week timetable. In terms of the 24th of October, I think I received a message from the team that they'd prefer the following week, probably for reasons due to school holidays, and but the timings on that week. I had understood that Mr. Trinick would be happy with 4 weeks for reports as well, if it's to be an inquiry. So I don't think that should cause a problem. I mean, this is going to be an inquiry which is perhaps unusual in that there are only going to be two parties. The parties are well used to interacting with each other, and I don't see any issues if the timetable is 4 weeks before for inquiry reports and 2 weeks for recognition.
Okay. Mr. Trinick? With that timetable?
Perfectly all right, content with that.
Okay, so that would move recognitions to the 28th of November, and then inquiry reports to the 14th of November. Okay, so that would, let me run through those proposed revised timelines. So we are content with all apart from, so on the 24th of October, it would be a second draft of conditions, if required, may not be, a final document list and a distribution of core documents by the 24th of October. Then we would be the 28th of November for recognitions. No, I beg your pardon. We would be the 14th of November for inquiry report and hearing statements rather than the 15th, I think. It would make more sense to have a single date. And then recognitions on the 28th of November, and then actual oral process 13th, 14th and or 15th of December. Written closing submissions, should they be required, the council the 23rd of December and the applicant on the 13th of January. Are those all agreed and in accordance with the practicalities of people's availability and commitments?
Yes, there's one point I should have mentioned, and that was the statement of agreed matters, which you've got down for the 26th. Certainly my experience is that if that was, it might be sensible to push that back, given my the most likely way of making progress on that will be on landscape and visual matters. My witness has only just been instructed, and whilst it would be useful perhaps to have the first draft of the statement of agreed matters on the 26th to provide for a longer time, perhaps I've forgotten the date, but say 2 weeks, the final version, say 2 weeks or so before the inquiry reports are due, or indeed perhaps on the 24th of October, to tie it in with the other dates.
Yes, that would, the 24th of October for a finalised statement of agreement would be fine.
Ma'am, can I just come back on that? The 20, if we're finalising statement of agreed matters and the inquiry reports on the same date, I'd rather we did the statement of agreed matters at least 2 weeks before that, because that will inform the final version of the inquiry reports and how certain matters are put. So maybe the statement of agreed matters by, say, the 10th of October.
I think Mr. Trinick's forgetting the inquiry reports are now going to be at the beginning of November, so the
Oh, sorry,
24th of October
Yes.
would give 2 weeks.
No, that's fine. Sorry, I
Is
got
that-
that wrong.
Yeah. No,
Thank
we have chopped and changed, but that, yes, that should be absolutely fine. So are all the parties content with the potential revisions? I will set out a timeline in time order attached to the note and make it clear when items are required to be submitted. Those proposed revisions are in principle acceptable, and I can't really see why we won't move forward with that revised timetable. Any other comments on key dates or timings before we move on? No? So moving to item 10 on the agenda, miscellaneous, but to remind you that Audrey Duhie is the DPEA case officer and will be your main point of contact during the process. She will liaise with Ms. Haywood and I as necessary and with yourselves as necessary, and she is responsible for making sure that all the relevant documents are circulated and made available on the website. The note of meeting will be circulated to all within 7 days of today's meeting, maybe earlier, depending on other commitments. Are there any other matters or issues that we haven't covered today that you feel should be covered, or is there any additional discussion on matters we have covered that you would like to talk about under item 11? No. Mr. Little, anything you'd care to add? Thank you. Well, that was a very efficient and timely pre-inquiry meeting. I congratulate all of us. I would like to thank you all for your participation today. We look forward to seeing you all in December, but obviously to hearing from you in accordance with the examination process over the next few months. As I said, we will finalise a note of this meeting, circulate it to all parties, and the resulting timeline will flow from then. Are there any last comments at all before I officially wind the meeting up? No, thank you very much. I would just remind you that if you could give some thought to the need for any accompanied site visits, if you could let us know. Looking to see the date, I said by the 16th of September, that would be much appreciated. And if not, please also confirm that you don't require any accompanied site visits. Right, once again, thank you all for your participation today, and we look forward to seeing you in December. Thank you.